case on the docket is Centurion Systems versus Federal National Mortgage Association.
May it please the court.
Good morning.
I'm Mark Stopa, counsel for the appellant. Would request 5 minutes for rebuttal.
Okay.
Your Honors, the amended complaint upon which the plaintiff traveled in this case did not state a cause of action for two different reasons. There is very little case law on the Florida DCA level about what's necessary to state a cause of action on these two issues. I submit that a decision reversing on either or both grounds is not only appropriate, but would be helpful for the many foreclosure cases and trial courts looking to employ the law on these issues. First issue, the one that I think has more broader application, is the what's necessary to state a cause of action on the issue of standing. Here in paragraph 3 of the complaint, this was the paragraph, the complaint and the amended complaint. The paragraph which sets forth the allegations vis-a-vis standing indicates plaintiff has the right to enforce the mortgage and note. A copy of the assignment of mortgage is attached and incorporated herein. That was it. No allegation of holder, no allegation of owner, no allegation of non-holder in possession, just a conclusory right to enforce and attaches an assignment. Now, the assignment of mortgage, which is attached, did not include the note. And Rule 1.115 clearly comes into play here, created by the Florida Supreme Court in order to clean up pleadings in foreclosure cases, and it specifically requires one of two things: that a pleading allege at the time the proceeding is commenced that the plaintiff is either the holder, which this clearly didn't do, or allege with specificity the factual basis by which entitled to enforce. Now, specificity sounds like a fraud standard, particularity. There's very little in the rules of civil procedure that require more than the standard ultimate facts. But in this context, we require specificity. Now, it was so clear at trial that paragraph 3 was insufficient to state a claim for holder that this trial was halfway through, and the plaintiff admitted they didn't plead holder. The judge was agreeing that they didn't plead holder. The judge wasn't allowing any testimony or evidence to support a holder or an owner theory. And the judge was basically there saying, all but saying, plaintiff, what are you going to do here? Are you going to just basically daring them to dismiss their case? And all of a sudden, it changed when the judge looked at a different complaint in a different case, and then the plaintiff took a look at their amended complaint, and they say, oh, paragraph 5 somehow changes it. Now, that's the paragraph where they talk about the default, and in that paragraph it says there has been a default under the note and mortgage held by plaintiff, and they act like, well, that now means that we state a cause of action as a holder. Several reasons why that argument has to fail. The first is that Rule 1.115 requires pleading holder at the inception of the case, at the time that the proceeding is commenced. And there's long-standing precedent from every DCA, as well as Rule 1.115, that requires standing be pled and proven at the time that the proceeding is commenced. Here, the allegation as phrased by using passive voice said, held by plaintiff. Well, held when? Both the amended complaint and the original complaint had that same phrase. Even if you interpret held as meaning holder, which I don't think that you can, because holder is the noun form is a term of art in the UCC, but even if you were to get past that, there's still the issue of, well, when was Fannie Mae saying that it was the holder of the note? The original complaint and the amended both said held in past tense. So taking those as true, they held at some point in the time previous to that without saying when. Certainly not with specificity as to when. So there was no allegation in either version of the complaint that Fannie Mae was the holder at the time that the proceeding was commenced, i.e. the filing of the complaint. Also, that allegation does not specifically indicate that the plaintiff held the note as opposed to just holding the mortgage, and we all know that an allegation of just holding the mortgage is insufficient. Now, I get that some of that might sound technical, but the concept of stating a cause of action is a rudimentary in jurisprudence. One of the first things that you learn about in civil procedure in law school. There's lots of cases that say that gives rise to a dispositive defense on the merits. You have to state a cause of action. It's not hard to do. They should have pled holder or something like that. They didn't do it, and that allegation in paragraph 5 just did not fix the problem. So that's the first reason why this court should reverse. It follows Florida Supreme Court Form 1.115, where they didn't want plaintiffs to be able to get away with this allegation, this broad, right to enforce without specifying what you mean. The Florida Supreme Court created a rule of civil procedure for this very fact pattern, created a rule of civil procedure to avoid litigants from coming in and saying, you have the right to enforce, as if that were sufficient. So under a de novo review, a reversal is appropriate on that first ground. The next ground, where reversal is appropriate also for failure to state a cause of action, is that both the complaint and the amended complaint said nothing at all about whether the mortgage was superior to my client's ownership interest. My client was alleged to be the owner of the property and to be in possession, and that's it. There was no allegation of whether my client obtained ownership before the mortgage was recorded or after. There was nothing in the pleadings that implicated that issue in any way. Now, I think it's odd that my opponent takes the position in their brief, well, that's an issue we had to prove at trial, but we didn't have to plead it. There are legions of cases that I cited some in the briefs, going back to the Florida Supreme Court's decision in Archie-Freed, for instance, that stand for the proposition that, if you have to prove it at trial, then you got to plead it in your complaint absent litigation by consent, and the trial transcript makes very clear I didn't litigate anything by consent, certainly not on the issues that we're appealing. So their position that, well, we had to prove this but didn't have to plead it, I think that doesn't even pass the initial smell test. And so then, sort of in that same vein, they seem to be taking the position without expressly saying so, or perhaps they're trying to say, well, this isn't an element of their cause of action. They didn't have to allege that the mortgage was superior to my client's ownership interest. Your Honors, I'd ask that you take a look at their own pleading. What does their own pleading do with respect to every other defendant? For every other defendant, the pleading says that the mortgage is superior to that defendant's ownership interest. It's spelled out one by one as to every other defendant, because that is what the essence of foreclosure is. That's what foreclosure is all about. The mortgage is superior to the interests of all of the defendants who are named in the case, and that's why those interests are all being foreclosed. They did not allege that with respect to my client at all. Now, the law tells us, and I've cited these cases throughout the brief as well, for instance, City Mortgage versus Henry, you cannot foreclose on an interest that is superior. The law does not allow foreclosure on an interest that is superior. That is why there has to be an allegation that the mortgage is superior to the defendant's ownership interest, or any defendant's interest, whether it be ownership or junior lien. In order to foreclose, you have to have that allegation, because without a superiority allegation, there is literally no basis in which to foreclose. And the cases bear that out by reversing foreclosures, even at the 1.540 stage, where the interest that was foreclosed was not an inferior interest.
Was this case tried, Mr. Stephan? Was this a trial?
It did go through.
Don't all the pleadings, aren't they all merged in what the evidence shows at trial?
Well, not when the issues are not litigated by consent and there was no amendment to the pleadings to conform to the evidence. And
saying that there was no evidence that the plaintiff had a superior position to your client?
no, there was evidence on that issue.
I mean, talking about pleadings after a trial is that's a difficult argument, isn't it?
Well, I don't think so, Judge. And understand, this is why.
Isn't it harmless error? Aren't we charged with the responsibility of only sending cases back if there's a harmless error?
Your Honor, failure to state a cause of action is not and has never been deemed a harmless error. They didn't even argue harmless error.
It is if they try the case and we find out from the evidence that they were right on the merits.
Well,
isn't it?
Judge, with all due respect, a failure to state a...
We're always respectful. Very passionate, I might add, about foreclosure cases, and I mean that as a compliment.
I appreciate that, Judge. So I like to make sure in the passion that I'm not coming across as anything other than that. So Failure to state a cause of action is never harmless error. You won't find a case that characterizes it as harmless error. And one of the reasons why I'm bringing it in at this stage of the posture is that it's the only way that I can, okay? Because when a motion to dismiss is denied interlocutorily for failure to state a cause of action, that's not appealable. I have to appeal at the end of the case.
I understand.
And we actually raised this issue in the motion to dismiss, both the motion to dismiss the original complaint and the amended complaint. The motion to dismiss the original complaint was granted, so they filed an amended complaint and did the same problem. And then we did the motion to dismiss the amended complaint on this same ground, and it's denied with no explanation.
Is there decisional law that you can put your finger on where the trial court denied a pretrial or a trial motion to dismiss for failure to state a cause of action, heard the evidence supplied the proof that was missing in the pleading, and the appellate court nevertheless reversed the case because of a deficiency in the pleading? Do you have a case like that?
I believe the Florida Supreme Court decision in Menendez does that, and that's the case which holds that's one of the cases where failure to state a cause of action can be done at trial. And Judge, I submit that, maybe you think that this error is interlocutory, okay? Maybe that's what I hear you saying, but...
No, I know you can't appeal until you've...
Sure. So if you were to accept your position as true, then what you're saying is that a defendant could never challenge failure to state a cause of action in a foreclosure case, because...
The trial judge can sustain it, and then the plaintiff is not able to put the proof forward, but if the trial judge overrules it and the evidence goes forward, then we have a situation where the plaintiff was correct on the merits.
But Judge, what you would be doing is you'd be ignoring the rule, which I cite in the very beginning of the brief, following the Schmilovitz case from the 4th DCA, which tracks 1.140, which says a defendant can raise failure to state a cause of action for the first time at trial. So the Schmilovitz case does that too. When a plaintiff does not state a cause of action, in addition to Menendez, when a plaintiff does not state a cause of action, the defendant can raise that for the first time at trial. So to accept your position...
True, but pleadings can be amended to conform to the evidence.
Okay, but that didn't happen here, and they didn't cross-appeal on that.
It happened de facto, right?
So if
They
you were
have to make a motion, is what you're saying?
I think that they would have to make a motion, and the motion would have to be granted, neither of which happened here. But to accept Your Honor's position would be to eliminate any appellate review ever of failure to state a cause of action in any case. Because if you...
When the judge grants it, we get them all the time up here on appeal.
Sure, when the judge grants, but when the judge denies, what Your Honor is saying is that when a complaint does not state a cause of action and an interlocutory motion to dismiss is denied, if the case goes forward to...
I'm just asking you questions.
I understand, Judge, but what...
You'll get our ruling in the mail, or electronically, I guess, nowadays.
What I'm trying to do is persuade you that your question on what the law might be shouldn't...
Go in there and you're trying to persuade me that I shouldn't, right?
I'm trying to persuade you to my position, Judge.
And I understand your argument.
And so, I want to make sure that it's clear that if you accept that position, then a motion to dismiss gets denied, the defendant can't appeal, and then go forward with a trial, and you say, well, if the plaintiff wins on the merits, then that just automatically fixes the failure to state a cause of action, then you can't appeal on that at the end of the case either?
Well, it doesn't always. It just depends on whether there was prejudice to the defendant and all of that, I mean.
But prejudice comes in when when you're talking about motions to amend to conform to the evidence or something like that, which never happened here.
Prejudice comes in when there's an amendment that you weren't prepared to address on the merits. When they throw something in, that leaves you flat-footed, and that if you had known about it beforehand, you would have been able to meet it with some sort of opposition.
Like Holder at the inception of...
You have never gone into a trial unprepared, I don't think.
Well, Judge, as much as I appreciate that, you shouldn't take hold my preparedness against me for purposes of the law, okay? Here, they didn't plead Holder at the inception of the case, okay? So as much as you might think I'm prepared going into that trial, I shouldn't be ambushed with a theory of Holder at the inception of the case that they didn't plead. That wasn't in the complaint at all. I didn't litigate that by consent, and the pleadings weren't amended to conform to to the evidence. So when they don't state a cause of action under Rule 1.115, the evidence that's introduced doesn't fix that. And look at how the lower court ruled. I think that the way that the transcript unfolds is fascinating, because the judge was agreeing with my position through the first half of the trial. You didn't plead holder. You don't get to prove that. You don't get to introduce evidence on it. I'm sustaining those objections, saying, counsel, what are you going to do? Which, Judge Lambert, from your foreclosure experience on the circuit court bench, I would submit, is basically saying, I think you guys need to take a voluntary dismissal. You're not going to win. That's where we were. And then all of a sudden it becomes this paragraph 5 fixes it? I'm sorry, it didn't. So where we were was we were at the stage where they didn't prove it. They shouldn't have been allowed, they didn't plead it, they shouldn't have been allowed to introduce any evidence on it because it was inconsistent with their own pleadings. The pleadings were not amended to conform to the evidence. We didn't litigate by consent. They didn't even argue that the pleadings were amended to conform to the evidence. They didn't even argue litigation by consent. We raised the issues interlocutorily and at trial. They should have fixed the problem at the interlocutorally. They didn't do it. So I get that some of these issues sound, technical, and you might not be excited.
Interlocutorally is a new word to me. Interlocutor.
I'm happy to create new words and new law on these issues, Judge. So I submit, you might not want to go back into your chambers and write up a decision for a third party who wasn't the borrower reversing a foreclosure judgment, but I ask that you follow the law in this context, and the law in this context shows that the plaintiff did not state a cause of action for either of the two reasons that I've stated, and given the relative absence of case law on this issue, given the interlocutory nature of how a lot of this is done, I submit a written decision would be helpful in these regards. Thank you, Your Honors.
Thank you. Good morning.
Good morning. Nicole Ramirez for Fannie Mae. May it please the court. Appellant concedes that Fannie Mae proved its case at trial. Appellant concedes that it's making an inequitable argument. So what else really is there to say? Standing was shown at the filing of the complaint by attaching a blank endorsed note. Standing was proven at trial by the admission of the original note with a blank endorsement matching the copy attached to the complaint. Superiority over all the defendants was proven at trial. Yes, the complaint did state a cause of action, even without use of the specific word holder. Even if there was an insufficient cause of action, the judgment would merely be voidable and not automatically void. There was no lack of due process, there was no prejudice, there is no reason to void the judgment entered at trial. The complaint did state a cause of action. It said there's a default of the note and mortgage held by the plaintiff. It attached a blank endorsed note. The blank endorsed note provided the factual basis for its allegation that it was entitled to enforce the note. Superiority over all the defendants was requested in the complaint. Appellant also concedes that it's not necessary to allege superiority over the borrower. Appellant says that's because it's assumed that the plaintiff is superior over the borrower because the mortgage is attached to the complaint. The mortgage is attached because, of course, that's the basis on which the action is brought, in addition to the note. The deed to the current title holder is not attached to the complaint. That doesn't form the basis for the action. If it's fine to assume that the plaintiff is superior to the borrower, that assumption, there's no reason to not apply that same assumption to the title holder, especially when it's just as obvious the superiority of the plaintiff to the title holder because the actual name of the title holder is trust dated 2012, many years after the mortgage was recorded. A mortgage foreclosure by its very nature would only name the title holder if it took subsequent to the borrower. you don't name in a foreclosure action all the previous owners of the property either. It's important to point out that this complaint was filed before the effectiveness of Florida Statute 702, which led to the creation of 1.115 Florida Rule of Civil Procedure, establishing some more specifics about what had to be pled. Even so, this complaint still stated a cause of action complying with that statute, which didn't even apply to this complaint. Plaintiff's allegation that it was entitled to enforce, rather than restricting its theories of standing, actually provided a more broad allegation. So there was no arguing of any theory not pled. The complaint also included the exhibits, attaching a blank endorsed note that provided facts sufficient to support the allegation that it was entitled to enforce. There was no trial of any theory unpled. The admission of evidence of the deed was a discretionary matter by the trial judge. The objection at trial that it was irrelevant because it was not pled, the court correctly ruled it was relevant. It was pled that Centurion was the title holder, so clearly it had relevance. There's been no showing of abuse of discretion of admission of the deed at the trial. This case is a lot like Voigt versus Galloway, Florida Supreme Court case, where conditions precedent were not alleged, were not pled, but they were proven at trial, and that judgment was affirmed. A procedural error having no effect on substantive rights should not be overturned. Also, just because the complaint says entitled to enforce and then references an assignment of mortgage, doesn't mean that that's the sole evidence that can be relied upon to prove the standing. Also attached was the note with the blank endorsement. Often at trial, other proofs might be necessary, such as print screens or the pooling and servicing agreement. This case is a really good example of why orders on motions to dismiss are non-final and non-appealable until the end. So you can get through the whole process and fix anything that might need to be fixed down the road. Yet, in this case, a cause of action was actually pled. The actual word holder is not required. The actual words alleging superiority over Centurion is not required. Yet it was pled, and it was proven anyway. The complaint followed the Form 1.944 established by the Florida Supreme Court, and it has been held as a matter of law that when a complaint follows a form established by the Florida Supreme Court, that it establishes a cause of action, it states a cause of action as a matter of law. The plaintiff provided competent, substantial evidence to support the judgment at trial, which should be affirmed. I know I've used a lot less time than I have. If there are no questions, I don't suppose there'll be any objections to me finishing early.
You want her to keep talking for 13 more minutes?
I could just throw out one more point to address.
Had to ask a question.
I'm asking you guys.
I would just point out that the discussion of the Menendez or any of the other cases talking about judgment given when there's no cause of action are distinguishable on the facts. They involved cases where perhaps there was a judgment that awarded relief that was not even asked for, or the cause of action is not like in this case, is just distinguishable on the facts. There is no case that reverses a judgment found on the merits for some apparent lacking to state a cause of action, and in this case, it was stated anyway. Also, just to address how the judge was agreeing, that's why we have trials, so the judge can figure out, whoa, this case is going off on the wrong track, that we really do have judgment on the merits here. So with that, I'll send it on back the other way. Thanks.
Thank you.
Sure.
You have about
Please
four,
support.
you have 4.5 minutes.
And I'm sure it's shocking, I'm going to use the whole time. Your Honors, there are several cases which are contrary to what my opponent just said. Donato is at 174 Southern 3rd, 1041. There, the 4th District reversed for
Hold on a
failure
second, I can't write that fast.
I'm sorry, Judge, 174
74
Southern 3rd, 1041. That's a foreclosure case where the 4th District reversed a foreclosure judgment and remanded for an involuntary dismissal because the complaint did not state a cause of action. That's the...
And it was a trial, and there was no proof of that at trial, is that what you're saying?
I believe so. I don't remember all the facts of that decision,
What I'm
and
looking for is a case where the pleading was deficient, but there was a trial, and the proof was adduced at trial and accepted, and so there was a disposition at trial on the merits. If you got one of those, I'd really be interested in you zeroing me in on it.
Shopler, Donato, Menendez. Shopler cited in the brief, Donato just gave you the case cite for. Menendez is a Florida Supreme Court case constantly used in this context. And I submit, Your Honor, I think it's telling. My opponent said, well...
I look at one case for that proposition. What's your best case that states that proposition?
I'm going to say, I struggle to limit it to one, but I'd say Donato if you forced me to.
Donato, which is the 174 Southern 3rd, 1041.
Correct. And particularly since that's a foreclosure case, a reverse to foreclosure judgment required an involuntary dismissal.
Trial in that case.
After that's the only time you can challenge a denial of a motion to dismiss for failure to state a cause of action.
You could do it a lot of other ways. Okay.
And so, Your Honors, my opponent takes the position, well, they proved their case at trial, and we concede they proved their case at trial. No, we don't, because and I made this clear in the last two paragraphs of the initial brief. They did not plead Holder, and I objected to any evidence of Holder because that was an unpled theory. And so the entirety of their evidence on this Holder concept, or Holder at the inception of the case, should not have been allowed to be introduced because it was contrary to what they pled. And that's the entire point of not litigating issues that are not framed by the pleadings. The cases cite the Archie-Freed case out of the Florida Supreme Court that sets forth that general standard, that you don't get to litigate theories which are not pled, or alternative theories which were not pled. And that's what they're trying to get away with, is that they had, and they don't even come before you and say that the pure legal conclusion of entitled to enforce is sufficient. They really don't even address most of these on the merits. They just want you to say, well, we proved these things, but they shouldn't have. My objections on the proof of Holder at the inception should have been sustained because that wasn't pled. And so they shouldn't have been able to substantively prove the issue at all. In other words, the way the first half of the trial went, where the judge was sustaining those objections, that's how it should have continued, and it should have continued with all of that evidence being excluded because they didn't plead that theory. And they don't really even have a contrary argument to that, except to try to point to this paragraph 5, which clearly has nothing to do with standing. They don't even try to show you anything in the complaint where they alleged Holder at the inception. So what they ask you to do is just say, well, allow us to get away with springing this evidence of standing and inception on them at trial when it wasn't pled, even though we raised this issue in 2 different motions to dismiss. Allow us to bring this before at trial, even though we contemporaneously objected. Your Honor, I submit, the question is, what's the best case that they could point to for the proposition that when I didn't litigate the issue by consent, that they should be able to introduce proof of a legal theory that they didn't plead? Right? If you frame the question that way, what's the answer to that question? There isn't one. There's no case that they can point to or that you could point to if you did when you do the research on this, as set forth in the briefs and otherwise, that allowed them to introduce evidence on a Holder theory that they didn't plead. And so all of the objections on that Holder at inception, standing at inception, should have been sustained, and the way that the evidence played out should have been totally contrary to what my opponent presents to you. The way the first part of the case was done was the appropriate way. And so, the other thing I can't help but notice, these are simple issues to fix. This concept of pleading a superiority, that's simple to fix. Just allege that the mortgage was recorded before the ownership interest. That's it. They didn't do that. That's all you have to do to fix the problem. So this isn't like an onerous issue that's going to, burden the banks going forward. They had simple things to do to plead these issues, and they just didn't do it. So reversal is required for either or both reasons. Thank you.
We'll take about a 10-minute break.